Max Schrems, privacy activist and lawyer, you're from Austria. You brought a very famous case through the entire system, through the European Court of Justice, and you were successful. Can you just walk us through a little bit about the background of your case?
The case we had at the Court of Justice was actually about mass surveillance by the NSA, where Facebook forwards data to the authorities in the US for so-called mass surveillance. So it's basically mass processing of data, or mass making available, to be legally precise. And that was the so-called safe harbor case back then. And we killed the agreement at the time to transfer data to the US because there wasn't any proper protection for European data if it went to the US.
And that resulted in a change of policy. We saw the new protection, that we moved from safe harbor to privacy shield. Has that answered your dilemma?
No, Privacy Shield is basically safe harbor with a couple of changes and a new headline. But the fundamental issue we have with the US in mass surveillance situations is that the US requires Facebook to forward all that data, and European law prohibits it. And there is a fundamental conflict between these two laws. And there's no agreement that can actually overcome that. The agreements we had so far were able to fill gaps, but in this case there's actually conflict of law. There's not a gap, there's basically too much law that conflicts with each other, and there's not really a way that an agreement could help there.
You invited back to the Parliament today as part of their investigation into the Facebook Cambridge Analytica inquiry. What is the overlap with your case? Obviously, it's a data protection question, but this is in a different domain. It's not national security. It's a company misusing data. Have lessons been learned?
So basically, before we went into national security, we also looked at what Facebook does with the data. And one of the complaints in 2011 already was that third-party apps can get all that data without really any restrictions. And that was the basis for something like Cambridge Analytica being able to be possible. So we actually looked at that 7 years before the public debated it. Back then, Facebook felt that there's no problem and it's all fine. Right now, today, I couldn't really listen if they found that there was a problem or not. They kind of say they're sorry. At the same time, they uphold that everything was right. So I'm kind of not really sure what their position is, actually. But that is fundamentally the problem, that back then they forwarded data to people where they had no clue where it goes. And in the end, we realized it went to Cambridge Analytica in this case. But there are thousands of other apps that probably sold the data as well.
Should we be reassured that we now have the GDPR regulation in place? Will that will that address the issues that you've raised in your queries?
We already had the law before. There was enough law in Europe about privacy. We didn't have the enforcement, and especially we didn't have penalties. So for companies, it was cheaper to ignore the law than to follow it. The problem now with GDPR is that especially the big companies like Facebook and so on seem to kind of follow that idea again, to kind of say, let's see if this is really enforced. We just have a different interpretation of the law. We just see it differently, and let's see if the courts ever decide. And if they decide, it usually takes 10 years anyways. And in that 10 years, you basically make the money for paying the 4% then.
You spoke in the hearing about addressing the monopoly situation that Facebook essentially has. What do you think the European Commission can do about that?
We basically have two issues. First of all, we need proper enforcement of the existing law. That is something that the data protection authorities have to do. That's a culture change in the authorities, if they really become enforcement authorities and not just kind of advisors or something like that. The other thing is really, I think, structurally in the long run, we'll have to look at de-integration or opening up networks online, because we have a very open internet that allowed us to communicate across borders and in a very open way. But on top of that, we now have closed networks that sit basically on top of this open infrastructure. And it's going to be interesting to take this European spirit we had in other parts to open up these networks as well, like having an open social network where I can communicate with someone that has another Facebook that is probably a better Facebook or a more privacy-friendly Facebook. And then we actually have competition, just like by now you can choose your cell phone provider or your, I don't know, electricity provider or train provider or whatever it is. We opened up all the networks. Just online we now see kind of a trend that goes the other direction. And that would be especially interesting if the European Union does something in that direction, because I think it would be something that all the different political parties could agree on. Like from a very conservative market-driven side, this could work because it's an open market and allows really innovation and competition, all the way to a very leftist approach of allowing consumers different choices. So I think that would be something where there should be a very broad political agreement that opening up networks is good for everybody, actually.